We're going to go ahead and get started. Hello, everyone, and thank you so much for joining us this evening. We are so honored to welcome Mary McCord, who is our speaker for tonight's program, Armed Paramilitaries and the Threat to the First Amendment. My name is Jody Brummage, and I am the Director of Education and Outreach for the Robert C. Byrd Center for Congressional History and Education. And before I introduce our speaker, I want to first thank everyone who has made this event possible. The support from our friends of the Byrd Center is crucial to providing these public programs, bringing accomplished and respected scholars to the Shepherd University campus and community. If you are joining us for the first time this evening, I would encourage you to visit byrdcenter.org and click on the link for the Friends of the Byrd Center, where you can learn about all the civics education initiatives and the ways that you can support us and become a part of our mission of advancing representative democracy by promoting a better understanding of the history of the U.S. Congress and Constitution. Mary McCord, our speaker this evening, is Legal Director at the Institute for Constitutional Advocacy and Protection, as well as a visiting professor of law at Georgetown University Law Center. As Legal Director at the Institute for Constitutional Advocacy and Protection, McCord leads a team that brings constitutional impact litigation at all levels of the federal and state courts across a wide variety of areas, including First Amendment rights, immigration, criminal justice reform, and combating the rise of private paramilitaries. McCord was acting Assistant Attorney General for National Security in the United States Justice Department from 2016 to 2017. Prior to this position, she was the Principal Deputy Assistant Attorney General for the department's National Security Division beginning in 2014. McCord was an Assistant U.S. Attorney for the U.S. Attorney's Office for the District of Columbia for nearly 20 years, and she is a graduate of Georgetown University Law School. McCord's work has included writings on domestic terrorism, unlawful military activity, public law, public safety, and the rule of law. Her writing has been featured in the Washington Post, the Wall Street Journal, Los Angeles Times, The Atlantic, Slate, Lawfare, and Just Security. She has also appeared frequently on NPR, PBS, CNN, MSNBC, and ABC, among other media outlets. Before I turn things over to Mary, I want to remind everyone that we welcome your questions for our speaker tonight. I invite you to submit those questions in the chat box, and at the conclusion of the lecture, I will then voice your questions to our speaker. And so it is my privilege to welcome Mary McCord to present tonight's talk on armed paramilitaries and the threat to the First Amendment.
Thanks very much, Jody, and it's a pleasure to be able to talk to you tonight at the Byrd Center. I was saying to somebody who I was presenting to today, it's like I feel like I go all over the country presenting, but I never actually leave my home. So I hope you're enjoying the beautiful spring weather in Shepherdstown tonight. So many of you will remember 3.5 years ago, the Unite the Right rally in Charlottesville, Virginia, not so far away from you, where not only those of us in Virginia and West Virginia and the United States, but people around the world watched in horror as white supremacists, neo-Nazis, neo-Confederates, together with their unlawful private militia supporters, really invaded this small town and engaged in not only violent and offensive rhetoric and language, anti-Semitic, anti-immigrant, anti-persons of color, anti-LGBTQ, but they also engaged in open street fights. In fact, they went there, we now know, because of the information that's come out about their planning for that event, they went there purposefully hoping to provoke counter-protesters into maybe throwing that first water bottle, taking that first punch, provoke them with their violent rhetoric into taking that first punch. And then the white nationalists would respond violently and invoke self-defense, provoke and invoke. But what was one thing that was also particularly shocking about that display in Charlottesville was that there protecting the white nationalists was a line of fully armed, fully military kit clad militia members. They were in full camouflage head to toe, combat helmets, flak jackets, combat boots, AR-15s, separate rounds of ammunition, magazines of ammunition, walkie-talkies, sidearms often. They deployed at set intervals along the south end of the park where the rally was supposed to take place. And they established themselves there ostensibly to protect the First Amendment rights of the protesters. Now, this rally, you may recall, was ostensibly to protest the city of Charlottesville's decision to remove Confederate monuments, the monument of Robert E. Lee and Stonewall Jackson. And just as a little aside here, litigation over the removal of those monuments resolved just last week when the Virginia Supreme Court ruled that the city could remove those monuments. So those will be coming down now. But 3.5 years ago, there was a protest about that. And that's what that Unite the Right rally was supposedly about. But these militarized militia members, and we're talking about self-professed militia members, the Pennsylvania Lightfoot, the New York Lightfoot, the 3% People's Militia of Maryland, American Freedom Keepers, American Warrior Revolution. Some had traveled as far away as the state of Washington to come to the Unite the Right, calling themselves patriots, saying that they were there to protect the First Amendment rights of the protesters. But they did this completely outside of governmental authority. They did this completely on their own, answering to no one but themselves and just determining for themselves when and under what circumstance they would deploy their lethal force. Well, my organization was very young at the time. I had just left the federal government after what you've already heard from Jody was a very lengthy career there at the Department of Justice. I'd been working counterterrorism for several years. I'd confronted the threats of international terrorists like ISIS and Al-Qaeda. And what we saw that day culminated, you may recall, in a car ramming in which a terrorist took his car and drove it right into a crowd of protesters, killing Heather Heyer and tragically injuring many others. And I thought, that's an act of domestic terrorism. And what is going on in Charlottesville with these militia units, these white nationalists using shields and clubs and spears and pole arms to engage in open air street fighting? This isn't protected by the First Amendment. The First Amendment doesn't protect violence. It doesn't protect threats of violence or incitement to imminent lawless activity. Second Amendment, it protects an individual right to bear arms, but it doesn't protect, for self-protection, by the way, self-defense, but it doesn't protect this ability to mass together as private individuals and form your own private army. So my organization actually used state anti-paramilitary activity laws to bring a lawsuit. We brought that lawsuit on behalf of the city of Charlottesville, its local businesses and its local neighborhood associations, not for money damages, not for the injuries. Other people brought lawsuits for money damages using the Ku Klux Klan Act and other civil rights statutes and tort statutes. This was all about making sure they couldn't come back armed as private paramilitary units, either engaging in offensive sort of warfare against their ideological opponents, like the white nationalists did, or engaging in this purported protection of other people's rights, because none of it did they have authority to do. And that lawsuit was successful. It resulted, after we prevailed in court on our legal theories, it resulted in court orders against 23 different individuals and organizations, preventing them permanently from returning to Charlottesville as part of a unit of 2 or more persons acting in concert while armed with anything that could be used as a weapon, firearm, shield, or anything else whose design is for use of a weapon during any protest, rally, demonstration, or march. Because it's hard to actually exercise your First Amendment rights to expression when you've got armed individuals engaged in paramilitary activity who are actually intent upon engaging in street battles. So what we saw, as shocking as it was, particularly when we looked at these militias, the hate and the violence by the white nationalists That was shocking and horrible, and we've seen proliferation of it. But what was also very troublesome to us was the fact that we had these armed individuals out there who looked so much like the National Guard that community members actually thought they were the National Guard until they would get close enough to see patches like Confederate flags and 3% symbols and things that clearly were not the National Guard. And that caused us to think about, why is it that these are proliferating throughout the United States? Now, if we can go back historically to the founding, and there have always been private unlawful militias, and they date back to the times of racial terrorist violence, tracking down first before the Civil War, tracking down escaped slaves and bringing them back to their owners. After the Civil War, they often tracked down people who accused of crimes were complicit in committing acts of racial terror, racial lynchings. In the 60s, of course, we've also saw militias engaged in that type of activity. But more recently, we tend to think of militias modern militias dating maybe to the 90s, where we had these armed standoffs against the federal government at places like Ruby Ridge, Idaho, and Waco, Texas. These are occasions where armed groups of individuals consider themselves sovereign citizens who don't have to answer to the federal government. That resulted in these armed standoffs. More recently, we saw that in Bunkerville, Nevada, at the Bundy Ranch, and in Malheur Wildlife Refuge in Oregon, just in 2013 and 2014. But again, these were standoffs against the federal government. This wasn't the militias interposing themselves with the public, showing their ability to use force or projection of the ability to use force and authority over others. That seemed to be a newer thing. And Charlottesville was one of the early really vivid examples of that. But since then, we've seen such a proliferation, and I just want to recount it very briefly. Of course, ultimately culminating in the insurrection at the US Capitol on January 6th. The most significant conspiracy charges so far to come out of that insurrection are against a dozen members of an unlawful private militia group who planned and plotted for the potential for that attack on the Capitol. They came armed, they were in military gear, they had coordination and control, command and control, and they stormed the Capitol with intent to delay or hinder or prevent entirely the tabulation of the Electoral College vote, which was constitutionally and statutorily required. But in the midst, what have we seen? So in these 3.5 years, we've seen more and more open public engagement by private militias. So think back to 2018, when there was a caravan of migrants coming up to the southwest border, a real tragedy and crisis in Latin America that was causing many to leave their homes, and it's happening again, of course, right now. At one point, former President Trump called on the military to go augment the Customs and Border Patrol at the border. In response to that, private militias around the country put out their own call to arms. You should go to camp to the border. You should assist the Customs and Border Patrol. But of course, these private militias, and some did go. One group set up a camp they called Camp Freedom right at the border of New Mexico and Mexico, very near its border with Texas, close to El Paso. And they, in, again, full military gear, AR-15 semi-automatic assault rifles, they detained migrants crossing into the US and held them with no authority whatsoever for Customs and Border Patrol. Now, one of their members is now serving a federal sentence for falsely assuming the functions of a Customs and Border Patrol agent based on that unlawful activity, serving a 2.5-year sentence. But this happened in multiple places along the border. We fast forward to 2019 in the fall, when the first impeachment investigation was ongoing, and there were some tweets about the potential for a civil war, some tweets that the former president himself retweeted, and a national militia organization, in fact, the very same organization whose members have been charged with conspiracy in the insurrection, they started tweeting to the president, "You just give us the word when you want to call us forth. We are trained, we are armed, our weapon of choice is the AR-15, and we will come when you call. We are in a hot civil war," they said.
Coming into 2020, this escalated. Of course, a year ago, right about now, or a month ago, a year ago, early March, as the pandemic began to rage across the country, we saw governors in a number of different states and public health officials use emergency authorities to try to prevent the spread of the pandemic. We saw shutdown orders, stay-at-home orders, masking orders, and in response to this, we saw private militias offensively storming state houses in Lansing, Michigan, and in Boise, Idaho, storming governors' mansions in Ohio and in Kentucky and elsewhere in armed, forceful opposition to government policies. Head to Memorial Day weekend and the killing of George Floyd and the spontaneous racial justice demonstrations that broke out across not just this country, but the world. We saw in this country that even though they were by far mostly peaceful, there were isolated incidents of violence and destruction of property. And in response to those isolated incidents, and in response to the former president and his surrogates blaming those isolated incidents on quote unquote violent anarchists or Antifa, we saw, again, armed private militias calling upon themselves, deciding to call themselves forth, supposedly in augmentation of law enforcement, to protect private property against these largely false rumors of violent anarchists or Antifa, when oftentimes it's really like a high school Black Lives Matter march. I got a call from concerned citizens in Sandpoint, Idaho, saying our local county councilman called forth the private militias, and when the local high school had a Black Lives Matter march to march across the bridge, and they had to contend with armed men with AR-15s, skulking at them and intimidating them. Is this legal? Well, no, it's not. And we're going to talk about that. Those calls came from tiny towns like Sandpoint, Idaho, to major metropolitan areas like Seattle, Washington, Portland, Oregon, Louisville, Kentucky, and everything in between. And then, of course, last year we had the election. And we had the seeding before the election of a false narrative about election fraud. Even before the election, this false narrative spread largely over social media about mail-in voting, much more susceptible to fraud. And if there's any result other than any result other than President Trump being winning the election, then it must be the result of a rigged election. These claims were doubled down on after the election, when the mantra then became stop the steal. This is a stolen election. There was massive ballot fraud. There was ballot box stuffing. There were places where the ballots were counted 2 and 3 times. This was the type of propaganda that was spread over the internet through extremist groups and through unlawful militia groups. And this became that coalescing justification for what we saw on January 6th. So throughout all of this private paramilitary activity, sometimes you would even see law enforcement officers saying, well, it's their constitutional right, so what can we do? They said that, the Kenosha, Wisconsin police chief said that after an armed militia member joined up with a local militia in Kenosha during a racial justice demonstration, ostensibly to protect private property, and ending up shooting and killing 2 people and seriously injuring another. And the police chief said, well, he was exercising his Second Amendment rights. We've seen that as an excuse made for storming state houses, as even a possible excuse made for the members of a militia in Michigan who plotted to kidnap the governor and try her for treason. Well, maybe these militia members were planning a citizen's arrest, one local sheriff said. So I want to correct the record on this. I want to dispel this mythology about the Second Amendment. So there are only 3 things you remember from tonight's talk. This is what they are. 1, there is no authority under federal or state law for private groups of individuals to amass together and form their own private army, their own private militia, not answerable to the governor. 2, the Second Amendment does not protect that. And the Supreme Court has been clear about that as far back as 1886. And 3, all 50 states, including West Virginia, prohibit private paramilitary activity. So let me go through those in a little bit more detail. Oftentimes you will hear militia members say, well, the Constitution protects a well-regulated militia. That's what we are. We have a commander. We always operate under a hierarchy of command and control. We're organized, we train, we drill, we are well-regulated. But well-regulated has meant, even since before the founding, meant regulated by the government. So as the colonies were first forming in the birth of our nation, they did not want to have standing armies. They were concerned about the threat to civil rights and civil liberties from standing armies. But they knew they needed some way to protect the colonies and the new states. So they thought they would rely on a militia, the militia being all able-bodied men who could be called forth by the governor in defense of the colony as necessary, and when so called forth, would be trained and armed and report to the governor. In fact, as far back as 1660, the Commonwealth of Massachusetts passed one of the early militia laws saying how important it was for a well-regulated militia to be the defense of the Commonwealth. This was ultimately baked into our Constitution. At the Constitutional Convention, at that time, actually, the framers were reeling from some armed insurgencies that had taken place. You may have heard about Shays' Rebellion and other insurgencies of the time, which were really about taxation. But this was something that was not authorized. It was against the state as opposed to in defense of the state, and the Congress and the framers wanted to avoid that, thus baking into the US Constitution not only the words well-regulated in the Second Amendment, but also giving Congress the power to call forth the militia, Congress the power to establish that the states could have their own militias, and the states could establish who the officers of those militias would be. And that is right there in Article 1 of the Constitution. So every state, in fact, then did that. The states, as they were forming and they were enacting their own constitutions, beginning with Virginia in 1776, their version of the Second Amendment included a strict subordination clause. It's been replicated in 48 states, all but 2, who have something quite similar to it, but not this exact language. But in 48 states, the language is almost the same in every one. And it says that in all cases, the military shall be strictly subordinate to the civilian authority, right? Meaning there's no rogue militias, there's no rogue militaries. The military is going to report up through the civilian authority being the governor. And in fact, the first militia acts then passed by Congress in 1792 allowed for the states to then establish what had been the militias even before the US Constitution into their official state militias. And what are those today? The National Guard units that we all know of, that every state has. In addition, many states also have an additional state militia. Sometimes it's called a defense force, sometimes it's called some other type of guard unit, but it always reports through the governor. And some states still have this vestiges of the idea of the unorganized militia, that being the all able-bodied men capable of being called forth, usually between certain ages, capable of being called forth by the governor when needed, in addition to the official defense forces. And do you know what happens when they're called forth by the governor? They then report up through the governor, oftentimes through an adjutant general. They're oftentimes absorbed into the state then militia if it's necessary. But there is no authority under state law or federal law for groups of people to say, we're going to form our own militia and we'll decide when we train, what we do, where we deploy, and we'll make our own decisions about when and under what circumstances to deploy lethal force. Second point, Second Amendment does not protect this. Oftentimes, private militias will take the Supreme Court's 2008 ruling in District of Columbia versus Heller. This is the first time the Supreme Court held that the Second Amendment protects an individual right to bear arms for self-defense. In fact, that case was actually even restricted to self-defense in the home. They'll say, well, if you take an individual right to bear arms and you're in an open carry state where the open carrying of weapons is permitted, that must mean that that necessarily means that we are constitutionally protected if we are a private militia. But actually the Supreme Court's been very, very clear that is not protected. In fact, this is one of the few areas of the Second Amendment where the Supreme Court has spoken, and has spoken more than once. And this dates back to 1886. After Reconstruction, a number of states passed anti-militia laws, and Illinois was one of those states. West Virginia is another one. These laws are pretty similar in all of those 29 states, and they bar bodies of men from associating together as military companies or military units, or parading or drilling in public with firearms. And in Illinois, that law was challenged when a militia was prosecuted for violating that statute. And the Supreme Court in 1886 said, there is nothing about this statute that infringes on the Second Amendment right to keep and bear arms. Moreover, the court said, it is without question that states must be able to prevent private paramilitary organizations in order to protect public health, safety, and good order. Fast forward to 2008, in that District of Columbia versus Heller decision, Justice Scalia, writing for the majority, in holding that there's an individual right to bear arms for self-defense, he pointedly contrasted that with private paramilitary organizations. He cited the Presser v. Illinois case from 1886, and he said, Presser stands for the proposition that the Second Amendment does not prevent states from prohibiting private paramilitary organizations. In fact, he said, nobody arguing for an individual rights interpretation of the Second Amendment has even questioned that states must be able to prevent private paramilitary organizations. So this notion that the Second Amendment protects them, the Supreme Court's been quite clear about. And in every other case that has addressed this, and there are not a ton, but there are some, which I can talk about in a few minutes, the courts have repeated the danger of private paramilitary organizations to public safety. They are a threat wherever they are, because they are not answerable to the government. They have no political accountability, and they are deciding on their own when to use that type of force. Okay, so that's point 2. Point 3, all 50 states prohibit private paramilitary organizations. 48 of them have that provision in their constitution I mentioned, which basically stands for the proposition that there are no rogue military organizations permitted. Any military organization in the state must report up through the governor. 29 states have the anti-militia provision in state law. Normally it's a criminal provision, the one that was upheld in 1886 by the Supreme Court. 25 states have an anti-paramilitary activity statute, and that's a statute that dates to the late 70s and early 80s when the KKK was opening training camps around the country to train in paramilitary activities in order to engage in different types of civil disorders. And that statute prohibits just that. It prohibits assembling with 2 or more persons to train, demonstrate, instruct, or practice in the use of firearms, incendiary devices, or techniques capable of causing bodily injury or death. So it wouldn't have to be with firearms. Think about those white nationalists using their shields and their pole arms in Charlottesville to offensively batter their ideological opponents. Those are paramilitary tactics. Those are barred if they're done with the intent to use them during or in furtherance of a civil disorder. So think about training camps, obviously, if they're training there to use these in a civil disorder, even if they're not going to further it, they're just going to use it during it, supposedly maybe to protect property while they expect another civil disorder, right? That's the kind of training it applies to. Practicing can mean practicing it in the moment, just like I practice law all day, doctors practice medicine. You're practicing these techniques while you're doing them. 25 states and the federal government actually prohibit that. Another dozen states prohibit this false assumption of the duties of a law enforcement officer or a peacekeeping officer, and that's to be distinguished from impersonation statutes. So impersonation statutes usually require you to actually be claiming to be a police officer, like have a fake badge and things like that. This applies when you're just falsely assuming the duties of a law enforcement officer without any authority. Because of course, in every state, not only is the militia heavily regulated, but the law enforcement is heavily regulated. It is all established by statute in every state in the country. And even security, private security is regulated. You can't just decide you want to be armed private security. In most states, there's licensing procedures, background check procedures, vetting, reporting requirements, etc. It's not just perfectly okay to say, I'm going to grab a semi-automatic assault rifle and gather with my friends, and we're going to be private security. That's heavily regulated. So about a dozen states prohibit that false assumption, as does the federal government. So you may be saying, okay, so if all of these states bar this, and if it's not protected by the Constitution, and if it's not protected by the Supreme Court precedent, why do we see private militias all over the country? Why did we see them at the Capitol on January 6th? Why weren't they arrested in Michigan when they stormed the State House? Now, of course, others were arrested for the plot to kidnap Governor Whitmer. Why weren't they arrested in Boise when they stormed the State House, or in Sandpoint, Idaho, while they were out there on the streets guarding property? And there are a few reasons for that, I think. One is, these aren't the bread and butter of local law enforcement, right? They're a little bit different. They haven't been used. Some of these statutes date from the 1800s. Many people have forgotten that they even existed. Even the statutes that date to the 1980s, although for me that doesn't seem that long ago, that's when I graduated from high school, it actually is quite a while ago, I hate to admit, and a few of you probably feel the same. And so it's not the bread and butter of local law enforcement, which are used to investigating and prosecuting your much more common and ordinary street crime. So that's one thing. They maybe don't even know about it. I've done lectures like this to groups of law enforcement who said, I didn't know we had that statute in my state. Some also might feel like they're not sure how to prove that case. How do I prove that a group is an unlawful militia? Because there's not a definition in the statute. And so there's some concern about trying to actually enforce a law where they are not exactly clear how to prove it. But there have been prosecutions, not only in 1886, there have also been use of these statutes civilly, not only in our case in Charlottesville, but also in cases brought against the militia wing of the KKK back in the early 80s. In Texas and North Carolina and elsewhere, people who'd been victimized by abuse and assault and threats from the militia wing of the KKK sued under these state anti-militia statutes and were successful in obtaining court-ordered relief, enjoining these groups from engaging in this type of armed paramilitary activity. And what the court looked at is, does the organization operate under a command and control and engage in training for or engaging in what are essentially combat or combat support type of operations with training and discipline and command and control. So there is precedent for it. And there are cases to point to for those who would want to enforce it. Another reason is some people will say, well, I think that this is protected by the Second Amendment, or I think that this is protected by the First Amendment. Well, we've just discussed why the Second Amendment doesn't protect this conduct, but neither does the First Amendment, because although it protects a right to peaceably assemble, and it protects a right to express your views, freedom of expression, these statutes are about conduct. They're not about content of speech. They're about conduct that is not peacefully assembling. It is conduct in forming a private military organization that the government has a substantial interest in regulating. And so the court in Texas, in the KKK case I mentioned, the Supreme Court in Presser back in 1886, other courts who've addressed this have rejected those type of First Amendment challenges. But this is, again, something not well known among the many, many, many hundreds of local police and district attorneys throughout the country. But I think actually an explanation that might be more realistic than any of those explanations is that oftentimes in the jurisdictions where private militias are most prevalent, these are jurisdictions that oftentimes are anti-government, very pro-absolutist view of the Second Amendment, and oftentimes pro-militia. And in fact, in some places, we've seen police and sheriffs actually supportive of private militias, in some case claiming that they exist to be a check on the tyranny of the state. There is a movement called the Constitutional Sheriffs Movement, by which sheriffs think that they are the highest law of the land, answerable to the Constitution and no other authority. But of course, it's the Constitution as they interpret it. Now, there's no authority for any of this, but it's a belief system that sometimes we see in some areas of the country. And certainly if you are an elected sheriff or an elected district attorney or an elected police chief, you might be very reluctant to actually enforce a case against the very constituents who elected you, even if you aren't ideologically aligned with them. So I think that there's oftentimes a great disincentive and little incentive to enforce these laws, even though they present a threat to the safety of law enforcement. They present a threat to the safety of the public, and they infringe First Amendment rights. I've had community members call me who wanted to go speak out in favor of different things in front of their county board meetings or their town councils, and they were in fear to go into the meetings because of these armed militia members outside the meetings. I've seen in Idaho last year, people with disabilities and at higher risk of COVID were afraid to go to testify against in favor of the mask mandate because private unmasked militias with AR-15s had stormed the Capitol and occupied the space, presenting a public safety threat to these people with disabilities, really to everyone, but the people who reached out were people with disabilities. I'm happy to say we represented them in a lawsuit against the Idaho legislature and now have achieved the opportunity for them to testify remotely, which sadly doesn't get rid of the paramilitary problem, but at least gives them an opportunity to testify without fear for their own safety. So one of the problems we have is simply a problem of political will. But I think what we saw on January 6th is important because even for those who maybe haven't really noticed this threat, haven't really experienced themselves, may think, hey, it's people who are out on private property on the weekend doing firearms training, it's not bothering me. I think what we saw on January 6th shows it's not just on private property on the weekend doing firearms training. Now we've seen, and I gave you examples of for the last several years of private paramilitary organizations more and more engaging with the public in very threatening ways. And we saw it, of course, on January 6th by some of these private militia groups who were aligned on that day with conspiracy theorists, violent extremists, and people I think who legitimately believed there might have been election fraud and came to Washington to express their First Amendment rights to protest, but then got swept up in the crowd, which became a mob, which was led by some of the unlawful militia members into storming and violently overtaking the State House. But I raised that point because I don't think it is just a local issue. It really is an issue that transcends local borders, transcends state borders, and is a national issue. So what I want to do is stop here to take your questions, because usually when I give this presentation, I usually do have a lot of questions. And so I want to make sure we have plenty of time for them.
Thank you so much. And I will kick it off with a question, but first I do want to invite everybody to please enter questions into the chat box so that I can voice them to Mary. So I was curious, and I think you mentioned briefly that there were examples of previous cases in response to paramilitary activity that were argued on the First Amendment, and the courts did not side or did not rule affirmatively in those cases. Mm-hmm. So I was wondering if you could provide some more detail about some of those precedent cases and how those arguments were shaped.
Sure, I can give a couple. So one is the case that I had mentioned earlier, which is the Vietnamese Fishermen's Association versus the KKK. And this is a 1982 case out of federal district court in Texas. And it arose because the militia wing of the KKK, which called itself the Texas Emergency Reserve, was going out, training for and parading and drilling and really harassing a community of Vietnamese refugees. This is after the Vietnamese War, who, were fishermen and were just exercising their own, rights on their own property to fish. And so this case was a civil rights case brought by the Southern Poverty Law Center, as well as other constitutional lawyers, invoking not only the Civil Rights Act, but also the state anti-militia law. And in granting the injunctive relief for the Vietnamese fishermen and enjoining the Texas Emergency Reserve from its militia activity, the court rejected a First Amendment challenge, rejected it saying this is conduct, this is not expression, and this is not the type of assembly that is protected because of the government's strong interest in protecting public safety against armed militias, which are a danger wherever they are. If we fast forward to our Charlottesville case, the defendants in our Charlottesville case made a First Amendment argument. And the court, in rejecting that argument, said there's nothing about this case that infringes on anyone's right to express their views, hateful as they might be, or to assemble together to express their views. This case is based on conduct. It's based on paramilitary conduct, which is ideologically neutral, content neutral. And in fact, I will mention here, one of the defendants in that Charlottesville lawsuit was a left-wing militia. So even though the militias do primarily tend to be on the far right side, many have aligned themselves pretty closely with white supremacy, even though many will deny that. They deny that and instead call themselves patriots that are supporting and defending the Constitution, but you don't have to scratch very far below the surface to see some ideological alignment with extremist views. But there are left-wing militias too. And in Charlottesville that day, there was a left-wing militia that did many of the same things as the other militias. They were there with their AR-15s. They formed fire teams around a park to protect counter-protesters and keep the police and others out. And they were defendants too, because it wasn't the content, it was the conduct. And so the court in that case rejected the First Amendment challenge. Similarly, going all the way back to 1886, the Supreme Court also rejected a First Amendment challenge. So there aren't a lot of cases. In fact, there are few, but all those that there are have successfully navigated this issue of First and Second Amendment rights.
So we have a question about is there a sense of how many people have been harmed or killed as a result of paramilitary activity in the United States? And I think speaking to the recent the examples that you shared.
Sure. So I don't actually have data on that, and we'd have to time frame it as well, of course. I don't think it's, the threat is not strictly just from, the threat of death. Obviously that's, very serious, but the presence does a lot of things that that the government has an interest in preventing. One, it tends to escalate the violence because or the potential for violence because you have people out there so heavily armed. So for example, even in Charlottesville, although some of these militias will claim, we prevented the harm, we got ourselves in between the protesters and the counter-protesters. But the reality is we're talking about a whole bunch of people out there with semi-automatic assault rifles. So it just kind of amps up the entire threat atmosphere. And I can say, and there were some shots fired, not by the militia organizations, but by others in Charlottesville. Happily, no one killed by shots fired. The person who was killed by a car ramming, and it was horrible and horrendous. But in other places, we've also seen that escalation to shots fired. So we are currently, right now, my organization is co-counseling with the district attorney in Albuquerque, New Mexico, in an enforcement action against a local militia there that had deployed out during a racial justice demonstration this summer, ostensibly to protect a statute of a Spanish conquistador that was being protested as disrespectful of indigenous people's rights, just like so many of our racial justice demonstrations this summer. And during that protest with these militia members, they are heavily armed. Again, it escalated. They got involved in the melee, escalated the melee. Another person with a weapon shot his weapon and actually did injure somebody seriously. So there are certainly those types of incidents of just it escalating the tension, escalating the violence. The other thing it does is it squashes First Amendment rights, right? Because if you are trying to have your own demonstration, and to do so, you have to pass by And I'll go back to my example in Sandpoint, but that wasn't the only place. I had people calling me from Broadway, Virginia, and Elkton, Virginia, and Bedford, Virginia, and places in Kentucky and Ohio and elsewhere, where they'll say, you know, we were just having our you know, small town demonstration. We had a permit and everything, and all these, you know, men came out with their AR-15s and their military kits. And is that okay? Because we were scared. We gave it up. We've also seen it, as I mentioned before, you know, in and around government buildings, which scares people from going and exercising their First Amendment right to petition their government with their grievances. And it shouldn't be just the people that have guns that to get to go see their elected representatives. In Virginia, in the summer of 2019, Governor Northam called a special session to consider gun safety legislation, and thousands of people came, and a private militia there then stood patrol on the line of constituents trying to get in, heavily armed, as though they had some authority to be patrolling this line. And it frightened some people enough that they just turned around and left and didn't have the opportunity to exercise their First Amendment rights. So I think we have to, you know, I just expand beyond, and that's why this talk tonight was talked about the threat for First Amendment rights, because it's a threat to public safety, but it's also just a threat to our democracy, to the ability for people to exercise their First Amendment rights. And of course, on January 6th, it was a threat to the very underpinnings of our democracy, meaning the peaceful transition of power, which is what makes January 6th so shocking.
So kind of following up on sort of the most recent incidents of this, there was a question about, has there been sort of coordinated paramilitary efforts to intimidate voters, intimidate polling places during elections, and how do recent laws that are currently being debated and some that have passed, such as the law in Georgia, perhaps affect the future possibility of those kinds of actions?
So we were very, very worried about militia intimidation at the polls last year. As I was talking, you know, last year was a very difficult year. The pandemic made things difficult. We had the armed militia activity in opposition to public health measures related to the pandemic. We had the militia showing up at racial justice demonstrations, and then starting in the summer, right, we had this propaganda, false statements about election fraud even before the election, which caused my organization, as well as researchers with whom I work with a number of researchers who actually are looking into social media, chat rooms, forums, monitoring extremism and extremist violence and militia violent extremism, which by the way, the FBI has recognized as one of the most significant, you know, terrorism threats in the country right now, from militia violent extremism tied with white supremacist violent extremism. So we were all very worried that in the dog whistle relationship that the former president seemed to have with some of these far-right extremist militias, you know, I forgot to mention this earlier, but when they stormed the state house in Lansing, the president's response wasn't, "That's dangerous, don't do this." His response was, "Liberate Michigan," in all caps, "liberate Minnesota, liberate Virginia, and save your great Second Amendment rights." Liberate being a word that is usually used to liberate a community from an occupying force, right? It has the whole penumbra of a wartime or end of wartime word. So this dog whistle call and response we'd seen throughout the year, many of us were worried, including many state and local officials were worried that this was just the kind of thing that private militias would use to say, we need to deploy to the polls to protect against voter fraud. So along with many partners, my organization put out fact sheets on militias. We put out a fact sheet for every state. You can go on our website and you can find those now, explaining what a militia is, why it's not protected by the Second Amendment, what the laws in each state are, and how armed militia activity at the polls could also be voter intimidation in violation of voter intimidation laws. We put out separate fact sheets on voter intimidation. We put out guidance for law enforcement. I worked with partners. State AGs came out strongly against armed voter intimidation. District attorneys, I did some press conference with district attorneys to get the word out. local sheriffs and police chiefs. I met with major city chiefs, the US Conference of Mayors, spreading the word. And the researchers with whom we work the most frequently, they said, guess what? Those fact sheets are circulating all over the militia social media. They're outraged at these fact sheets. And on the day of the election or the day before the election, one of the national militia organizations, and you may notice I'm not naming any of these organizations because they thrive on that publicity. One of the national organizations put out a directive to its members not to go to the polls in military uniforms with guns, that it could be voter intimidation. They quoted from our fact sheets, and then they actually included a link to our fact sheets at Georgetown. So yes, we were very worried about polls, and it didn't happen. My organization and a whole coalition of law firms that we brought together for this very purpose last year, we monitored the election protection helpline throughout the entire day from East Coast to West Coast. We monitored for every report of voter intimidation, and we saw zero private militia activity at the polls. We had a few instances of like a single individual with a gun. The most we saw was 4 individuals with guns across the street from the polling place, not in military uniforms, just waving flags. Not good, but not the kind of thing that we were expecting. So it's a really good question. We were very worried about it. It didn't end up happening. The Georgia law, I don't think has anything in it that I'm aware of that goes directly to this. I will say though that every state has some sort of no electioneering zone around the polling place. And so a lot of the discussion about the Georgia law has talked about this rule that you can't provide food or water to anyone at a polling place. And Georgia was using the idea of no electioneering as its justification for prohibiting food and water, that they wanted to make sure nobody's getting in that zone and trying to convince somebody to vote for a particular candidate. Of course, electioneering, the terminology is about passing out flyers or buttons or trying to convince people about who to vote. It's not about providing water. And one of the things we needed to try to clear up last year is sometimes people would confuse this no electioneering zone with, does that mean right outside the no electioneering zone you can have a militia? No, the militia laws have nothing to do with the no electioneering zone. It could be voter intimidation in the no electioneering zone. It can be voter intimidation outside the no electioneering zone, because not only do the militia laws apply everywhere, but voter intimidation laws apply everywhere. I mean, if I go to your house and intimidate you about the vote, I can be nowhere near a polling place. I'm still committing a crime. There's a lot of, I think these no electioneering zones often create in some ways more confusion than they address, but voter intimidation is unlawful everywhere, and certainly armed voter intimidation is unlawful.
So there's a question, said, is there any significant intelligence being gathered on the embedding of paramilitary groups within law enforcement or within the military?
So this is something I actually just did a presentation earlier this week along with General Russell Honore and their former police, where we discussed this very issue. It's less about the paramilitaries embedding within, but there are definitely problems of military members, active duty, and in particular veterans, as well as active duty and former police being involved with private militias. In fact, some militias specifically recruit from police and the military because they want people with that skill set, right? They want people who know how to use firearms, including not the kind of firearms that people would normally have for self-defense, the kind of firearms that people use in military operations, people trained in paramilitary tactics and techniques, people who know about incendiary devices. And in fact, the organization who has a dozen members charged with conspiracy coming out of the insurrection are members of an organization that specifically recruits from law enforcement and the military. And the data, we don't have full numbers, of course, because you don't actually know how many there are unless they've been, called out either through some sort of investigation or indictment or charges or have been dismissed. But we know, even just coming out of the insurrection, that, and not all of these are militia, but there's been upwards of something like 40 veterans or active duty. Most were veterans. I think only a handful of active duty military. And there's been about a half a dozen police who've been charged with crimes coming out of the insurrection. I will tell you, in my own experience, some of the militias that were our defendants in the Charlottesville case were led by veterans. And I actually ended up having some very frank and cordial conversations with these men, one of whom said to me, you know, Mary, this is my life since I got back from Afghanistan. You know, this is what I do all day. I mean, these are my buddies. This militia is, you know, this is how I've been able to manage, you know, leaving the mission that I had in Afghanistan. And so I've been starting to talk with folks on Capitol Hill. And when I do presentations like this, you know, there is a real place in Veterans Affairs to provide a mission for our veterans. I think it is so important because people who've spent their careers in the military or in government, as many of us have, who are used to being very mission oriented, it can be a big loss to not have that anymore. Now, some are probably ideologically on the far right, and having another mission isn't going to change that. But there are plenty of missions that don't require AR-15s and military kits, right? Assistance in food drives, assistance in disaster relief. There's so many things that could be provided to give that sense of mission. And I think it's a real challenge for the country to step up to the plate and provide our veterans with causes that they can feel, those who are looking for that can feel that they can devote their time to without having to resort to something like a private militia organization.
And sort of in the same track, are there known examples where paramilitary activity has stood in the way of local law enforcement performing their duties? And if so, how did law enforcement respond to that challenge to their authority?
Well, I'd say that we see this almost every single time and every example I've discussed. I mean, if we start with January 6th, the law enforcement was utterly overrun by the crowd. Now, granted, not all that crowd was paramilitary, but there were militia members who were at the forefront of violently overthrowing the police, making it impossible for the police to hold the line, and violently entering the Capitol. In Charlottesville, the police felt that it was frankly just untenable and unsafe to try to get in the middle of the melees where the unlawful militias were, as were the other, white supremacist paramilitary organizations doing street battle with counter protesters. So they stood back rather than, and were thwarted in keeping the peace because of the potential to just cause it to be worse if they were to, storm in their riot gear. During racial justice protests, we saw police resorting to very hard policing methods, including, chemical weapons and other non-lethal weapons in order to dissipate the crowds at times, but they were also, in Kenosha famously, and this might be what the person asking the question was asking about, in Kenosha famously, there was a reporting of some of the police thanking the militia there. But if you actually heard from the police chief the next day, he did say, it's a threat to our law enforcement when you've got that many people out there with weapons that are more powerful than what the police carry on a day-to-day basis. And so some are aligned with them, and that's a whole other, problem we have with extremism in the police that we were just talking about a minute ago. But others, it really does thwart their ability to engage in policing activity. In the State House, storming the State House in Lansing and in Boise, the police were just unable to repel that type of firepower and that type of manpower in a way that could be safely done.
There's a couple questions that have come in regarding, I think, sort of the defining of paramilitary, how that differs from, is that different from domestic terrorist? Is that different from militia? And if so, is there a federal recognition or a licensing or some kind of monitoring of these groups that sort of officially designates them as a paramilitary?
There's no official designations. And in fact, I would say some private militias actually say, whoa, we're not a militia. You know, we're a patriot organization that is devoted to defending and protecting the Constitution. So you really have to look at what they do and not what they put on a label. There is no statutory definition of militia other than all able-bodied men capable of being called forth, right, by the governor in defense of the state. But what we're talking about here is, you know, organized paramilitary units. So the term militia, paramilitary organization, somewhat interchangeable. But the key features that the courts have looked at it, have focused in on, are those things that are sort of core to what is a military organization. So command and control, training, discipline, you know, for some sort of combat or combat support or law enforcement type role. Now, law enforcement, you might think, well, isn't that a little bit different? But think about our National Guards, right? Our National Guards are allowed by law not only to engage in what are traditional military functions, but also in law enforcement functions, which is different from our federal standing military, which due to the Posse Comitatus Act is not allowed to engage in law enforcement. But the National Guards have more leeway there. And so it can be that kind of law enforcement as well. So there's no designation process for these at the federal level. And certainly there's no licensing because there is no, you know, there is no legal way in any state or in the federal government to say, I want to be a private paramilitary, can I get a license? Because it's just unlawful. But I will say in terms of monitoring, and I will emphasize here, law enforcement, federal law enforcement and state and locals should not be ever monitoring any organization based solely on First Amendment protected rights. But if there is reason to believe that they're engaging or maybe engaging in unlawful activity, including private militia activity, or including any type of, you know, accumulation of weapons to use in a terrorist attack or anything like that, any indication of that, law enforcement can investigate. And the FBI has, and the Department of Homeland Security have both in public testimony, not only talked about the threat, the threat in the US right now, the terrorism threat is the greatest from racially motivated violence. Within that category, white racially motivated violence, but also militia violent extremism is another significant category. And right now, the FBI has this domestic threat at its highest threat level for terrorism in the US. And that, you know, that's new for the FBI to put it at such a high priority, but domestic terrorism is not new. I mean, our country, frankly, is founded on it. That's what racial, you know, lynchings were terrorism. We haven't called it that openly until recently, some people, but, you know, in more recent history, even before, you know, some of the recent examples like El Paso and Poway and Tree of Life, the lethality from domestic terrorism in the US was greater than the lethality from international terrorism in the US. More people killed from what we think of as domestic extremist causes, even though white supremacy is not unique to the US, it's as international as anything else, but more people killed in furtherance of domestic extremism than foreign terrorist organization extremism like ISIS or Al-Qaeda.
So I'm going to say a last call for questions in the chat box. If you have any questions that have come up in this incredible conversation, please enter them now. But I want to ask one question that I'm curious about because the Byrd Center does teacher training as a part of our programming work. And last year we had a session that dealt with Congress and the power to make war, but in that a lot of teachers asked about the idea of militia in the Second Amendment. Mm-hmm. And I was curious, you mentioned how early on Congress passed laws to sort of define what militia meant or to perhaps redefine it from what it meant in the various states throughout the constitutional ratification. Mm-hmm. And I was wondering if you could speak to what were those factors? What led Congress to pass those laws at such an early date to sort of define this stage?
Yeah, so really a lot of work had been done before that, because as I indicated, even before the founding, more than 100 years before the founding, the colonies were relying on militia for the defense of the state. And militia always meant under the control of the governor.
You can go back to the 1600s, early 1700s. The colonies were passing their own militia acts. And their militia acts provided for the governor to call forth able-bodied men when in need to defend the state. And it would be well regulated, they would be armed, they would be trained by the state. So that was already very much in existence when the framers met to discuss, what the federal constitution would look like. And of course, based on federalism principles and other constitutional principles, there was even at that time still this desire not to have a standing army, and we didn't have a standing army there at the beginning. But we needed to. The Congress knew they needed to, memorialize the state militias as something that could go forward even after the founding, right? So that's why they gave Congress this authority by the Constitution to provide for the calling forth in aid of the federal government, but also provide for the authority for the states to memorialize and formalize their state militias. So that took place. Congress then passed the Insurrection Act and other acts that allow for the federal government to call for the militias of the states when necessary to suppress rebellion or insurrection. And it passed the Militia Acts, which allowed for the states to, solidify their state militias, reporting up through the governor, and decide how to, have their own officers and their own internal command structure. Ultimately, when the National Guard Acts were passed, coming forward in history, those primary state militias were, turned into essentially the National Guard, but the states also have authority to other militias. So it wasn't like a new idea at the time of the framing. It was really about, I think, memorializing in the Constitution what was existing, but always under the authority of the government. And there is another thing probably worth mentioning for those of you who really watched District of Columbia versus Heller. That case is the case that decided that the Second Amendment protects this individual right to bear arms. That was a very, very debatable proposition. I mean, many of us would say it's still debatable. That's what the Supreme Court has held. But the law until District of Columbia versus Heller really seemed to point the other direction. It seemed to point in the direction, and by the law, I mean Supreme Court cases prior to Heller and just history seemed to support that what the Second Amendment protects was a right to bear arms in service of your position in the militia. So you could only bear those, the only thing it protected was your right to have a weapon for use in defense of the state. That was rejected by a majority of the Supreme Court over vigorous dissent in District of Columbia versus Heller in favor of this individual right. But even under the Heller decision with the individual right, again, Justice Scalia pointedly contrasted that with private paramilitaries and said, there's nothing about the Second Amendment that protects private paramilitaries.
So I think that this is a good question to kind of wrap up the evening with. And I do see that you provided a link in the chat box. So several of you have been asking about, where you can find these resources. There's a link in the chat box, but there's a question or kind of two questions I'm going to put together here. One is, what do you see as the path forward in managing this situation? And at the same time, I would ask, are there other places you would encourage people to look to learn more about this subject?
Yeah, it's a great question because, right now there's just little stopping these organizations other than, occasional criminal charges if they do something like an insurrection. So we have a couple of initiatives I'm working on. One is civic education. I mean, honestly, that's why I try to never turn down an opportunity to speak to groups of people, because for every one of you listening, if you can just keep those 3 points in mind, you're going to tell somebody who's going to tell somebody, and it will dispel this mythology of the Second Amendment. This mythology is new. It has not always been this way, but the mythology is so widespread and prevalent, like I said, that even police officers sometimes assume that these are protected organizations. And I'm not even talking about police who are ideologically aligned. I'm just talking people who honestly believe it. In fact, when I speak, normally I have people when it's in person come up to me afterwards and say, that was the aha moment. We assumed this was protected by the Second Amendment. So civic education is important. Support for state attorneys general and state
district attorneys and law enforcement. And like I said, we're paired up with the Albuquerque district attorney right now. We've been reaching out. I addressed the National Association of Attorneys General last week, again today, working with different attorneys general to see what they might be able to do to enforce their laws. Now, in some states, the state attorney general doesn't have general criminal enforcement authority. Sometimes that's only the local electeds that have it. So what can they do? And then I've also been talking to members of Congress, Republicans and Democrats, Senate and House side, a number of different committees about the need for a federal anti-militia law like the one upheld by the Supreme Court back in 1886. Because even though federal law doesn't authorize it, there is no federal law that prohibits private militias. And because this is not just a local problem, because this is a national problem, as we've seen, it's something that I think needs the attention of the federal government. So there's a lot of staffers and congresspeople interested in that. I'm going to be testifying later this month in front of one committee. And so it's something I think to get a discussion about.
Excellent. Well, thank you so much for this incredible talk, and for, I think for a lot of us, as somebody in the comments put it, taking a situation that really often to us seems totally out of control and really helping us to have a frame of reference for how to understand what's going on and you know how we can move forward in addressing this issue. So thank you so much for taking the time to join us tonight, and thank you to everyone who attended for your excellent questions and for keeping the conversation going. Before you leave, I just want to invite you to our next program. Our next virtual program is coming up on Wednesday, April 21st. And we will be welcoming Phil Baker-Shank, Native American law attorney for Holland and Knights in Washington, D.C., who will be presenting a lecture entitled Native American Indian Policy Since Little Bighorn. And the information on that event is available on the Byrd Center's website, byrdcenter.org, where you can sign up to receive the Zoom link for that program. So again, thank you, Mary. Thank you, everybody who joined us tonight. And please have a good evening and take care.